Morning, good afternoon, and good evening. Welcome to Course 4B of the Monique and Roland Weil People's Academy of International Law. I am Marjorie Cohn, Dean of the People's Academy and a member of the Bureau of the International Association of Democratic Lawyers. Our topic for today is the criminalization of rights and human rights defenders as a means of repression. Our faculty for this course includes Kyung-Yuk Jang, Jeffrey Frank, Galo Chiriboga Zambrano, and Natalie Segovia. Each of them will speak for about 30 minutes, then they will comment on each other's presentations, followed by questions and answers with all of you. We have French, Spanish, and English translation. Please put your questions in the Q&A box for our discussion. In the next few days, we will post on our website at peoplesacademy.net the faculty presentations in English, French, and Spanish, along with links to relevant articles. Attorney Kyung-Yuk Jang has been a member of Min Yuen, Lawyers for a Democratic Society, since 2000, and a diligent advocate for the public interest. As of April 2020, Min Yuen was comprised of more than 1,200 lawyers from all parts of South Korea. At Min Yuen, Jang served as Deputy Secretary General, Chairman of the U.S. Military Affairs Research Committee, head of the Task Force on Abolishing the National Security Act, and Vice President. As a human rights lawyer, he has defended numerous cases alleging violation of the National Security Act. He is thus nicknamed Spy Case Lawyer. Jang exposed the truth in the spy manipulation case. He represented the victims who were forced to be spies through a process of unimaginable human rights violations. He has been constantly attacked by conservative forces, including attending a 2013 seminar in Potsdam, Germany, where North Korean officials were also present, without the approval of the authorities and being accused of violating the National Security Act for making anti-American claims at the seminar. Jang will discuss the law of evil above the Constitution, South Korea's National Security Act. Jeffrey Frank is a graduate of the University of Minnesota Law School. He received his Juris Doctor in 1980, and New York University School of Law, where he received his LLM in taxation in 1981. He is a member of the National Lawyers Guild and currently co-chair of the National Lawyers Guild's International Committee. In 2002, Jeff became a member of the Friends of the MST, or FMST, the US-based solidarity organization with Brazil's landless worker movement, MST. In 2009, he became the national coordinator of FMST. The FMST connects the MST with social movements in the US, Canada, and Puerto Rico in order to build international solidarity. Jeff attended the MST's 5th Congress in 2007 and helped lead a delegation of US and Canadian social movements to the MST's 6th Congress in 2014. Jeff has worked with various legal organizations in Brazil, including the National Network of People's Attorneys and the Association of Brazilian Jurists for Democracy. He has spoken at various legal conferences in Brazil over the years. Jeff will discuss the criminalization and suppression of landless workers' movement in Brazil as a struggle for the control of the land. Galo Chiriboga Zambrano served as Minister of Labor in Ecuador from 2005 to 2006, and he was the Attorney General of Ecuador from 2011 to 2017. Gallo has been a lawyer in private practice in Ecuador since 1984. In 1977, he received his specialization in labor law from the Central University of Ecuador. In 1979, he earned a master's in administration in Medellin, Colombia. And in 1984, he became Doctor of Jurisprudence from the Pontifical Catholic University of Ecuador. In 1999, Gallo earned a specialization in human rights from Robert Schuman University in Strasbourg, France. The former president of the American Association of Jurists, AAJ Ecuadorian branch, he was decorated with the National Order of San Lorenzo in 2007. Gallo will discuss lawfare against human rights defenders, the case of the Ombudsman of Ecuador. Natalie Segovia is a Quechua international human rights attorney whose work as executive director of the Water Protector Legal Collective, an indigenous-led legal organization born out of the No DAPL resistance at Standing Rock, focuses on the protection of water protectors and frontline defenders, the earth, and indigenous peoples affected by forced displacement, desecration of sacred lands, and human rights violations due to extractive industry. Natalie's international work includes human rights field work, documenting violations in rural, unseen areas in countries including Colombia, Peru, Bolivia, and Brazil, and at the United Nations. A frequent lecturer in law, in 2022, she was named Givelbert Distinguished Public Interest Lecturer at Northeastern University School of Law, where she taught a course called In Defense of the Sacred, Human Rights, Earth Justice, and the Law. Natalie holds a law degree from Arizona State University and dual degrees in political science and Latin American studies from Columbia University. She currently serves on the scientific committee of the People's Academy of International Law and on the board of directors for Indigenous Peoples' Rights International. Natalie will discuss unseen lawfare, struggles to protect protectors, human rights, and the earth. Our first speaker will be Zhang. Zhang, go ahead.
네, 안녕하세요.
Hello,
네,
everyone.
오늘 한국의 국가보안법 탄압
Today,
사례를
I have a
발표하게
speech
된
for
정동균
the
변호사라고
national
합니다.
security law in
어,
South Korea, which
이
is the
자리에
evil law above the
초대해 주셔서
Constitution. Thank you
감사합니다.
for inviting me. I'm honored to be here.
한국에는
South
헌법
Korea
위의 악법이라
has
부르는
national
국가보안법이
security law.
있습니다.
It's the evil law above the Constitution.
국가보안법은
The
1948년
national
12월
security law
1일에
was enacted on December 1st,
조선민주주의 인민공화국을
1948.
불법화하고 다익성향 정당과 사회단체를
They
국가별로 하나의 목적으로
illegalized the BPRK,
몰아서 탄압하기 위해서
Republic of
상시적
Korea,
법률로
to
제정되었습니다.
repress the progressive people and suppress
이
left-wing
국가보안법은
parties and the social organizations for the
대한민국
purpose of
정부와
subversion.
조선민주주의 공화국 정부 수립으로 분단된 적대적 냉전 체제를
This is the fascist
강화시키는
law, a product of the
도구로서
hostile Cold War system,
민중의 불만과 저항을
not
억압하는
abolished even
파시화법으로
after the
지금까지
demise
자리
of
잡고
the
있습니다.
leftist forces in South Korea after the 1950
한반도의
Korean War and
남북
the
분단은
enactment of the Criminal
1950년 한국
was
전쟁으로
ordered entrenched as a product of the
현재까지도
repeatedly divided
전쟁이
ceasefire
멈춘
and
정전
hostile
상태로
Cold War
유지되면서
system to suppress the discontent
국가화법이
and
한국
resistance
사회에서
of the
가장
Korean people.
강력한 영향력을 행사할
Excuse me,
수
Don,
Okay.
we're not getting the English translation. It's breaking up. Can you
Okay,
directly into the microphone, please?
let me try again.
Okay, you
One
can keep
moment.
going.
Do you
Yes,
hear me now?
Yes.
Do you hear me now better?
Yes,
Okay.
you do. Mhm.
So this is the fascist law, a product of the hostile Cold War system, was not abolished even after the demise of the leftist forces in South Korea.
네,
In South Korea after the 1950 Korean War. Today, it is the most politically and socially powerful law in South Korea society,
긴장과
operating as
대결의
a
시대를
censorship
유지하고
device
있는
that not only
독재적
criminalized
왼정
the
체제
thoughts and the expression of South Koreans, but also invisibly binds every single thought and expression of South Korea.
형사처벌하는 것을 넘어서 국민의 생각과 의사표현 하나하나를 눈에 보이지 않게 얽어매는 검열 장치로 작동하고 있습니다.
So it is the product of the hostile Cold War system was not abolished even after the demise of the leftist forces in South Korea after the 1950 Korean War. In Korean society, the national security law has quickly neutralized the basic rights guaranteed by the Constitution and has become an evil law above the Constitution that regulates the state and the society, contrary to the constitutional ideology of realizing democracy and guaranteeing basic rights. And now I will show one of them representatives of the poisonous articles of the national security law.
독소조항입니다.
There are representative 2 articles, 2 and 7. Article 2, paragraph 1, which defines the Democratic People's Republic of Korea as a anti-state organization.
대한민국 모든 국민의 생각과 의사표현을
Actually, it means
형사처벌하는
defining the
실조
Democratic
조항입니다.
People's Republic of Korea as an
실조 조항은
anti-state organization
사냥 고무조항이라고도 하는데요.
refer to a democratic or foreign association or group with a command and control system that aims to subvert the government or subvert the state.
이하의 징역에 처하고 있습니다.
So Article 7,
중에 먼저 2조의
there are some praise and incitement, etc.
조선민주주의인민공화국을 반국가단체라고 지칭하고 국가로 인정을 하지 않습니다.
Right.
조선민주주의인민공화국은
To add something more in Article 2,
공산화하는 것을 목적으로 대한민국에 대한 지속적인 안보 위협의 주체이기 때문에 반국가단체로 규정을 하고 있습니다. 반면에 미국의 한국 주도는 대한민국의 공산화를 방지하는 효과적 억지력이라고
the Republic of Korea claims that the Democratic People's Republic of Korea is an anti-state organization under Article 2 of the National Security Act. This is because the DPRK pose an ongoing security threats to the Republic of Korea with the goal of communizing the Korean Peninsula through military force. While the U.S. military presence in South Korea is an effective deterrent to prevent communization. Because the national security law defines the Democratic People's Republic of Korea and its citizens as anti-state organizations and members of anti-state organizations that pose an ongoing threat to the Republic of Korea. By their very existence, the Democratic People's Republic of Korea is not a state, but an anti-state organization. and is subject to the penalties of the National Security Act. Although the Democratic People's Republic of Korea is a member of the United Nations since 1991, the national security law undermines the principle of sovereign equality and the obligation to respect sovereignty in Article 2 of the United Nations Charter, as it designates the DPRK as an anti-state entity and criminalized its citizens as a member of the anti-state entity. The national security law is a key tool for reproducing hostilities with hostile and coercive laws that do not recognize the other side of the divide, the DPRK, as a state and subject to the other side to criminal punishments. The opinion of the DPRK are not even subject to free debate among the citizens of the Republic of Korea, because they are criminalized for being the same or similar to the opinions of the other side of the divide. Citizens of the South Korea are not allowed to engage in dialogue and debate beyond hostile, slanderous claims about the other side of the divide, the DPRK. So as long as the national security law exists, the government of the Republic of Korea contacts the government of Democratic People's Republic of Korea on the basis of the national security law, which is a hostile and coercive law against the DPRK. Therefore, dialogues and the negotiation between the authorities of the two Koreans, which are not premised on a spirit of mutual respect as parties to the division, will only delay and impede the peaceful resolution on the division. Now I will introduce some of the cases of the victims of the national security law. In 1980s and 1990s, there are several cases of the violation of the national security law, but it is actually still ongoing in active nowadays. So it would be better for you understanding of South Korea societies. So let's take a look at the cases of repression under the national security law, focusing on the UN Human Rights Committee's decision on individual complaints filed by victims of Article 7. You can see this presentation. So now I will come to the Kim Geun-tae. You can see the number of the communications. In 1989, January 21, Mr. Kim was charged and punished under Article 7 of the National Security Law. And because of distributing the propaganda handouts included opposition to the US and Japanese neocolonization of the Korean Peninsula, and also the withdrawal of the US troops from South Korea and the suspension of the joint military exercise between the US and South Korea. So in this sense, he was violated of the national security law. If this propaganda includes a position against the US and Japanese, then he is committed by the national security law. And second case is the Park Tae-un. While studying at the University of Illinois at Chicago from 1983 to 1989, Mr. Park was arrested in August 1989 upon his return to Korea for his activities with the Korean Youth Union. These unions had concluded many youth in South
그
Korea
단체는 대한민국의 당시 군사 정부와 그
under the
정부에 대해
military
지원을
dictatorship
하는 미국의 지원에
regime.
대해 매우 비판적인 견해를
This
가지고 있었습니다.
organization was designated as the anti-US organization,
회원으로 활동하며
and he was
미국으로서의
active
대화 시위에 참여하여
against the US struggles
외치고
and
동조하였다는
slogans
이유로
against the US.
이분은 국가보안법 7조 1항
So,
이적 동조 및
by the
7조
national
3항
security
이적
law,
단체 가입죄로
he was
구속되고
arrested
입건되었습니다.
and
미국에
punished.
있는 재미 한국 청년 연합이
While studying abroad in the US, he was charged and punished under the Article 7 of the National Security Law for participating in peaceful rallies and demonstration in the US as a member of the Youth Union of South Korea University. And third case, next is the Shin Hak-cheol.
네, 세 번째 신학철 사건입니다. 화가가 그린 창작 행위를 국가보안법 7조 5항
The artist's act of creating the painting was prosecuted and punished as a crime of making a transferred expression. Article 7, paragraph 5 of the National Security Law.
봐주시기 바랍니다.
And you can show the presentation at the for the picture of the planning. Can you go to next presentation, which is showing the picture, the planning picture. This is the confiscated painting, rice planting. The upper part of the painting is very richly painted, meaning the Democratic People's Republic of Korea. And the lower parts symbolize the Republic of Korea, depicting the power of the colony captor and the dictatorship. And it was prosecuted and punished as a actually it is against the DPRK, and it is aligned with the cautions and claims of the DPRK. So this artist also was arrested and imprisoned.
네, PPT가
And next is the Mr. Lee Jong-un case.
네. 네. 이정은 사건은 이정은 씨는 건국대 총학생회 부회장으로 선출되어 한국 대학 총학생회 연합의 대의원으로 활동한
He was a student leader of the university students organization. He was a cadre in the organization, and he was elected vice president of the students association and served as a delegate to the Korean Federation of University Students Association.
민족 통일을 이루려는 전략을 뒷받침한다고 한 청년을 이적단체로 몰아서 국가보안법
The Korean authorities charged and punished him under Article 7 of the National Security Law and Article 7, paragraph 3 of the National Security Law for sympathizing with a terrorist organization and joining a terrorist organization because his activities and beliefs were similar to those of the DPRK, which supports the DPRK's strategy of achieving national unification by communizing the country.
조선민주주의인민공화국의 정책 실현에 도움이 되고 이들이
all of the involved victims of the national security law who filed individual complaints with the UN Human Rights Committee were arrested, detained, criminally prosecuted, and convicted for their expressive activities or membership in organizations. The persecution of the punishment of the above victims was based on the grounds that their expressive activities and membership in organization were identical or similar to the views and the claims of the DPRK, that they helped to realize the policies of the DPRK, and that they pose a threat to the national security of the Republic of Korea by advocating for the withdrawal of the U.S. troops and the suspension of the U.S. ROK joint military exercise, which are contrary to the policies of the United States and the Republic of Korea.
명백한 위험이 어떻게 야기되었다는 것인지 정확하게 특정되지 않는 한 조선민주주의인민공화국의 안보 위협이 상존한다는 것만으로는 표현의 자유와 결사의 자유 제한 이유가 될 수 없다는
The purpose of the Human Rights Committee's individual complaints decision. In its decision, the committee concludes that the punishments of the above victims under Article 7 violates Article 19, freedom of expression, and Article 22, freedom of association of the International Covenant on Civil and Political Rights. The committee's conclusion is that the mere existence of a security threat in the DPRK is not a sufficient reason for restricting freedom of expression and the freedom of association unless it is precisely specifies how the apparent danger posed by the victim's individual expression and membership of the organization was caused. The reality of South Korea's national security law, I can explain next in presentation. On September 26, 2023, the Constitutional Court of the Republic of Korea declared Sections 7 of the National Security Law constitutional. The National Assembly of the Republic of Korea has not repealed the National Security Law, which violates international human rights instruments, but has maintained and appealed it. And the prosecutors and the courts in the Republic of Korea continue to apply the national security law to prosecute and punish. This is contrary to the recommendation of international human rights threats bodies to amend and repeal the national security law. All South Korean citizens are at constant risk of the punishments under Article 7 of the National Security Law. As any South Korean citizen who is similar to or sympathetic to the views, claims, or action of the DPRK, an anti-state organization, pose a threat to the existence or safety of the South Korean state and is subject to punishment under the national security law. There are certain arguments and activities that Korean nationals may never make because they are punishable under Article 7 of the National Security Law. So South Korean people cannot say about the withdrawal of the U.S. troops out from South Korea or stop the U.S.-South Korea joint military exercise. Anything or really or literature to read about the DPRK, it's never happened in South Korea and cannot any access the information about the DPRK. Any propaganda or promotion or contents of the DPRK, all this information is not allowed and impossible to access. Any books or newspaper, broadcast, movies, song, YouTube, TikTok, or internet, and from the DPRK, it's not allowed. People of South Korea have no access to any information about the thoughts, politics, economy, culture, and society of DPRK and are blocked from any serious access to and activities related to the DPRK other than the condemn, denigrate, and hate the DPRK in accordance with the U.S. policy of hostility toward the DPRK. this national security law is the fastest law that covers the eyes, ears, and the all mouths of the people of the
시간
South
좀
Korea.
남았나요?
Do we have time more? Can we use
Yes.
more
Yes,
time?
we have about 7 minutes, Don.
네, 그러면 그 간략히 저와 관련된 국가보안법 탄압 사례에 대해서 간략히 설명하는 것으로
Okay, thank you.
발제를
Then I will
마치겠습니다.
finish my speech today.
저는
With my case, dealing with the
어,
cases of the national security law.
민주공화국의 사람과 국제적인 세미나에서
I have experienced to participate in the events to talk about the crisis of the Korean Peninsula
평화협정 체결을
and also demands of the
전 세계
peaceful
남과 북을 포함한 전 세계가
reunification.
싸워야 된다라는 이런
Actually, this event was
발표를
many.
했다는 이유로
This event was very peaceful, and many participants from all over the world, including DPRK. But because of this event, I was repressed, suppression by the national security law. Not only DPRK, there were many foreign participants. And this event was held in Germany. And many officials from other countries. And when I go back to South Korea, there was the most conservative media called the 조선일보. And this conservative main media says that I incitement and praise the DPRK, and I demand the withdrawal of the US troops from South Korea. And this demands is similar with the DPRK. Even though I tell the truth about the ceasefire of the background of Korean history and the purpose of and our goal of the withdrawal of the US troops out, but although I'm telling the truth, but I was arrested, I was a wanted person from the prosecutors by the national security law, because I had a speech next to the DPRK officials in the event. And the media said, if you know that the event has included the participants from the DPRK, why you had a speech and had a seminar together with them? And why you have a discussion with the officials from the DPRK, which is the similar idea from them. And many repressions and criticals opinions on me at the time. So as long as the national security law, even though I'm a lawyer in South Korea, although I defend the people human rights, I'm only not the exception. I was also repressed by the national security law. So there is no exception if the activities related with the DPRK, then any people can repress by the national security law. And actually it is like can be a slave of the law, the national security law. And actually, thanks to the Roland Bay, from the IADL, he have international solidarity from France, and I can
적극적으로 지원할 수 있는 그런 용기들이
I
많이
have more
부족했지만
courage and
오히려
support
프랑스의
from the
변호사님께서
French lawyers,
저를
Roland Bay,
지원하는 국제연대의 손길을
and with the many international
보내주셨습니다.
solidarities.
오늘 롤랑 베이
So I
변호사님과
appreciate
사모님을
it
추모하고 그 정신을
and
배상하는
keep
국제법
memory of
아카데미에서
him and his
국가관법
wife.
발표를 하게 된 것을 진심으로 영광으로 생각하고
And still,
끝까지
I
경청해 주셔서
really appreciate for
감사드립니다.
his international solidarity, also for all of from the words to telling this story of the Korean South Korean, which is the evil law. And I'm very honored to be here to have a speech to tell this truth of the national security law. Thank you all.
Thank you so much, Jung, for explaining the repression caused by South Korea's national security law and how it's aimed to prevent reunification between South Korea and North Korea. And thank you also for mentioning the important contribution of Monique and Roland Vale, for whom our People's Academy of International Law is named, for their solidarity work with Korea. Thank you so much. Our next faculty member is Jeffrey Frank. Jeff?
Excuse me, I got to get the set up. My mistake, sorry. Get the screen share set up, sorry. Oops. Is the screen up there? I don't see it.
Yes, it is up there.
Okay.
It is. We can see it.
Okay, thank you. Today I'm going to talk about the criminalization and repression of peasant movements in Brazil and the resistance of the landless workers movement. In order to understand land conflict in Brazil, we need to go back to the beginning, the Portuguese colonization of Brazil in the 1500s. When the Portuguese stole and redistributed indigenous lands, they divided them into capitanias and sesmarias, as shown on the slide, which resulted in large land holdings, which continue to these days. The Portuguese developed a factory-like process for sugarcane that was labor-intensive, requiring the forced theft and enslavement of over 5.5 million Africans, the largest number in the transatlantic slave trade. Brazil was the last country in the Americas to end slavery on May 13, 1888. Brazil has always had land conflicts. During the 20th century, with the increase in urbanization, conflicts increased in the countryside. The Ligas Camponesas, or the peasant leagues, threatened the power of the rural elite. When President João Goulart backed the peasant leagues, the military backed the rural elites in their demand for a coup to avert land reform. The military launched the coup in 1964, and that continued with increasingly harsh repression until 1984. By the early 1980s, strikes in the auto plants and other basic industry, student revolts, and massive demonstrations for Direitos Já, or Direct Elections Now movement brought the end of the military dictatorship. In 1988, Brazil adopted a new constitution, which, due to the power of the social movements, political parties, and labor organizations in ending the dictatorship, is a very progressive document. We're going to focus today on this clause of the Brazilian Constitution. The Brazilian Constitution requires that land serve a social function. As such, the Constitution requires that the Brazilian government expropriate, for the purpose of agrarian reform, rural property that is not performing its social function. According to Article 186 of the Constitution, the social function is performed when rural property simultaneously meets the following requirements: rational and adequate use of available natural resources, preservation of the environment, compliance with provisions which regulate labor relations, and exploitation which favors the well-being of the owners and workers. For purposes of the MST, the first one, rational and adequate use, has been defined as that the land is being used for purposes of production of food for the population of Brazil. So therefore, fallow land or unused land is subject to expropriation. The first land occupations were spontaneous, beginning in 1979 in the southern state of Rio Grande do Sul. Those were soon joined by others, and indeed, by 1984, the landless workers movement was founded with the slogan of "Land for those who work on it." That was the year of their first Congress. The Movimento dos Trabalhadores Rurais Sem Terra, or the Movement of Rural Workers Without Land, the MST, has been in existence now for 40 years. The map on the right shows the occupations by the MST and some other agrarian reform groups. The map on the right shows settlements of land conquered for agrarian reform during the 40-year period of the MST. The MST has been an incredibly successful organization. Between 1985 and 2023, the MST won land rights for more than 450,000 families, over 2 million people, organized in over 2,500 agrarian reform settlements on 7.5 million hectares of land. About 65,000 MST families occupy unproductive land in 1,000 encampments awaiting approval to begin farming and developing settlement. These and other excerpts are from the political organization of Brazil's landless workers movement, a dossier by the Tricontinental Institute for Social Research of April this year, which will be included in the materials you'll receive after. The MST is organized into various sectors: production, education, health sector, communications. Other MST sectors include gender, culture, youth, international relations, human rights, mass front, training and political education. The pictures shown here are of the MST's national school near Sao Paulo, the dining room, the library, the field where they work on agroecology, and the administration, one of the administration and classroom buildings. Also included with your materials will be a complete listing of their accomplishments. Now we're going to focus on the repression and criminalization of the MST and the MST's resistance. I'm going to look at 6 topics: attack on civil society, violence and intimidation, the propaganda war, use of the judicial system, lawfare, congressional attacks, and Bolsonaro's attacks on the MST during his presidency. First, we need to look at why land is in conflict in Brazil and why the political inequality exists in Brazil. So as you can see, land concentration in Brazil. About 1% of the landowners control 50% of the nation's farmland. Wealth inequality, you can read on the chart, 1% of the population controls 49% of Brazil's national wealth. And the bottom 50% of the Brazilian people own less than 1% of the national wealth. This translates into political inequality. The Ruralista Caucus, a multi-partisan organization of elected representatives dedicated to defending the interests of agribusiness, brings together 324 members, or 61% of the lower house of Congress, and 50 members, or 35% of the Senate or the upper house. The first attack was on when Lula was first elected They tried to dismantle his government using the Lava Jato corruption scandals as an attack on the Workers' Party. While all parties and segments of society were in on the corruption, the prosecutor focused on the Workers' Party, Lula's party. The second attack on civil society was the impeachment or the parliamentary coup of Dilma Rousseff. So the Workers' Party had 2 terms of the presidency under Lula, and Dilma had 1 complete term and then was elected to her 2nd term, and that was enough for the rural elite and the rural and work elite of Brazil. They accused her of violating the Constitution through budgetary irregularities, which everyone used. On August 31st, 2016, they convicted her impeachment and removed her from the presidency. Michel Temer, our center-right neoliberal, became the president. As part of the process of resisting the impeachment of Lula, the MST and the Workers' Party helped form the Brazilian Association of Jurists for Democracy. They also helped form international support. In the US, it was the US Network for Democracy in Brazil. The third attack on civil society was the trial, imprisonment, and ultimate exoneration of Lula. Again, this centered on supposed corruption of Lula, an apartment given to him as a bribe. But it was exposed during the course of actually after the trial and the conviction that the judge in the case had colluded directly with the prosecution by discussing the evidence to use in order to convict Lula. The MST and the Workers' Party established the Free Lula encampment. They set up outside the prison where Lula was incarcerated. The encampment remained in place during the entire 580 days of Lula's imprisonment and served to keep the issue in the public eye. Since violence against peasant movements has been common throughout Brazilian history. However, since the country's redemocratization in 1985, 1,742 people, mostly peasant activists, have been murdered in Brazil as a result of agrarian conflicts. Less than 3% of these cases were ever brought to trial, and only 14 of the rural elite who hired the gunmen to carry out such crimes have been convicted by the courts. Violence against peasant movements is evidenced by the CPT, which is the Pastoral Land Commission of the Catholic Church of Brazil, in their 2022 survey, recorded 2,018 incidents of social conflict in the countryside, a 33.6% rise from the average figure in 2016, and includes 47 murders linked to land or environmental issues. The massacre at Eldorado dos Carajás, which occurred on April 17, 1996, is one of the most egregious examples of this impunity. By 1996, the MST was operating in every region in Brazil and had won land for thousands of families. With its agrarian reform settlements receiving support and solidarity throughout Brazilian and international organizations and individuals. However, the MST was not yet seen as a relevant political actor in the country, as it was unknown to most of Brazil's urban population. That would soon change. That year, 1996, thousands of peasants marched on Belém, the capital of the Amazonian state of Pará, to demand a public hearing with the government. In Eldorado do Carajás, in southern Pará, the peasants were surrounded by the police and gunmen who had been hired by powerful companies in the region. State military and private gunmen began to fire tear gas as well as live ammunition from rifles and machine guns. 19 landless were killed immediately, 2 died later from injuries, and 69 were wounded. To this date, only 2 people have ever been brought to justice, and these were lower echelon people, not the people who hired the gunmen. However, it was not this tragedy that transformed the MST into a recognized political force, but rather the way the movement responded to the repression. In February of the following year, in the face of police impunity and the paralysis of agrarian reform, 1,300 MST activists began a long march from 3 starting points across the country that was set to arrive in the capital, Brasilia, on April 17, 1997, exactly 1 year after the massacre. At that time, the Minister of Agrarian Development agreed to meet with the marchers only because he was convinced they would never complete the roughly 1,000-kilometer journey to Brasilia. Nevertheless, the 3 MST columns entered the capital on schedule with 100,000 folks there to greet them. This demonstration of strength and organization transformed the MST into a major player in Brazilian politics, a position it holds to this day. The response to violence by the MST has always been to organize national and international support. For example, in 2005, the MST organized a march to focus not only on the violence in the countryside, but also the increasing financialization of agriculture by the incursion of international finance capital and international agribusiness. The march began from May 2nd to May 17th, 2005. 15,000 landless workers pitched tents along the route every day, creating effectively a small mobile village with infrastructure for bathrooms, kitchens that provided food, facilities that allowed the children who were accompanying their parents to keep up their studies at the end of each day. To ensure organization in the ranks, a portable radio transmitter sent messages to 15,000 radios carried by the peasants. After the march, the Brazilian army invited an MST leader to deliver a lecture to learn how a grassroots movement had achieved such a high level of organization. Additionally, in response to the massacre and mounting legal and violent attacks throughout the countryside, the MST organized the National Network of People's Attorneys, or RENAPE, the propaganda war. Next. Globo is a network of a large media consisting of television stations, radio stations, newspapers, magazines, and internet sites. João Pedro Stedley, one of the leaders of the MST, describes the global network role in the parliamentary coup of Dilma in this way. The global network became the main party of the Brazilian bourgeoisie. It protects the interests of capital, uses its force of manipulation of public opinion in coordination with the ideological sectors of the bourgeoisie, which include the judiciary power, some prosecutors, and the press in general. They know that Brazil and the world are going through a serious economic, social, and environmental crisis caused by capitalism. That, in Brazil, became a political crisis because the bourgeoisie needed to have hegemony in Congress and in the federal government in order to apply their plans to put all of the negative effects of the crisis on the shoulders of the working class. Therefore, the global network is an ideological author of the coup. Global and other media present without evidence the MST as an occupying land not for agrarian reform, but to take control for the profit. The MST has countered this by setting up its own communications networks, journals, magazines, radio stations, website, Brasil de Fato, a weekly newspaper, and Expressão Popular, a publishing company. MST also counters the propaganda against it with direct interaction with the public, farmers markets throughout the country, retail stores and cafes, as well as food donations, which I'll discuss below. The MST has used its massive base in its settlements to mobilize not only MST militants, but urban workers. Fourth, use of the judicial system, lawfare. Rural elites have attempted to evict the MST from land that has, under the Brazilian Constitution, been expropriated and given to the MST for settlement for cultivation, as well as land occupied by the MST that does not fulfill the social function required under the Constitution. There are two prongs to the eviction attempt. First, the use of private militias and/or state police to evict through violence and intimidation, some of which we've just discussed. And second, the use of the judicial system to try and return ownership to the rural elite. One example shown in the slides at Campo Grande, the attempted eviction of 450 families from land occupied for 19 years. The MST resisted this first by having its attorneys submit the eviction threat to the United Nations Special Rapporteur on Adequate Housing, who issued a report denouncing the destruction of the school on the encampment, the eviction of 6 families, and the threatened eviction of more than 450 landless families. The MST launched a media and social network campaign that sent thousands of letters and emails to the court handling the eviction. Eventually, the eviction orders were nullified. The second campaign was during the zero eviction campaign during the pandemic. During the pandemic, the Brazil Federal Supreme Tribunal instituted a moratorium on evictions. This was challenged, and the MST helped initiate the campaign for zero evictions, which generated over 50,000 letters and emails from around the world. The eviction moratorium was maintained. So how does the MST generate such international support? Internationalism is built into the MST model. The MST sends brigades to assist in agricultural and agrarian reform to countries around the world, including Haiti, Palestine, Zambia, Mozambique, Venezuela, Cuba, and the Basque Country. In the US and Europe, the MST has cultivated committees of friends of the MST that have endured for decades. The MST makes direct connections with social movements and political organizations in order to enhance the interconnectedness of the peasant movements, including the founding of La Via Campesina, which is a worldwide organization consisting of over 200 million peasants through hundreds of organizations. Since 2023, October of 2023, the MST has sent almost 20 metric tons of food to aid the people of Gaza. The fifth attack on the MST has been through what's known as the Parliamentary Commissions of Inquiry, or the CPIs. Their congressional investigation have been used in a variety of situations, but against the MST, they have been used in an attempt to adopt laws to criminalize it. The first CPI took place in 2003 and sought to force the President Lula's administration to distance itself from the MST, as well as to prevent public funds. It failed. The 2023 CPI investigation, led by members of the most radical core of former President Jair Bolsonaro's coalition, had similar goals to pressure the new Lula administration into disconnecting from the MST. The MST launched an international campaign, I Am With the MST, that mobilized thousands around the world in a campaign of letter writing to the Parliamentary Commission. They mobilized attorneys and law professors to analyze the CPI and testify to its utter lack of basis. And of course, they brought thousands to the streets. In the end, the CPI against the MST failed, and the commission was not even able to issue a report. Why did it fail? Well, by the time of the 2023 investigation, the MST's public image had been strengthened as a result of the solidarity activities it carried out during the COVID-19 pandemic. This in turn increased solidarity with the MST and thereby deprived the Commission of political or media support, leaving it unable to even file a final report. During the pandemic, while the Bolsonaro government ignored the suffering of people without work, food, and in many cases, housing, the MST provided over 10,000 metric tons, which equates to almost 10 million kilos or 22 million pounds of food to the Brazilian population. Sixth, Bolsonaro's attempts to criminalize the MST. From his first day in office, Bolsonaro made it clear that attacking the MST was a priority. In April 2019, in a live transmission on Facebook, Bolsonaro affirmed that he was seeking to classify the occupation of the movement as acts of terrorism and defended the idea that property owners can shoot and kill occupiers without it being considered a crime. In his first week in office, extrajudicial violent attacks against the MST encampments increased. On January 5th, 2019, before the government had even completed 1 week in office, the first act of violence was recorded. Private security agents killed a person and injured another 8 in an occupation in the state of Mato Grosso. The declarations of one of the gunmen hired to attack the encampment said he was influenced by the climate of permissiveness for violent actions. Indeed, 2 gunmen were arrested but were released 2 days later. The government discontinued all processes to buy and demarcate land for settlements. The agency dealing with agrarian reforms was essentially shut down. The Special Secretary for Land Matters called the schools of the MST, quote, little factories of dictators, close quote, and said the government would work to close these institutions where more than 200,000 children and youth study. Families in Pernambuco were surprised by an eviction order, usually a violent eviction order, as you can see in this, where they burned down, in the slide where they burned down all of the tents and structures, leaving the people with nothing. But Bolsonaro failed in his attempt to criminalize the MST. As stated before, during the pandemic, Bolsonaro ignored the suffering of the Brazilian people, while the MST used its organization and resources to feed the hungry people. These actions created a bond with the poor and working class in Brazil. This is why the MST has been able to survive and prosper over its 40-year history. During and after Bolsonaro's government, numerous complaints were lodged against the Bolsonaro with the International Criminal Court. In August of 2021, the Articulation of Indigenous Peoples of Brazil filed a complaint with the ICC denouncing the government of Bolsonaro for genocide. They listed 2 crimes. The first crime is a crime against humanity. It consists of the, quote, extermination, persecution, and other inhuman acts against the indigenous. The second is causing severe physical and mental damage and deliberately inflicting conditions aimed at destroying indigenous peoples, an act classified as genocide. Bolsonaro has been accused of crimes against humanity at the ICC for his record on the destruction of the Amazon. These complaints were launched by dozens of NGOs worldwide. A Brazilian congressional panel recommended that Bolsonaro be charged with crimes against humanity, asserting that he intentionally let the coronavirus rip through the country and kill hundreds of thousands of Brazilians in a failed attempt to achieve herd immunity. And it's shown on the screen. The organization I previously discussed, the ABJD, filed a complaint with the ICC for crimes against humanity for Bolsonaro's response to the human rights, to the pandemic, I'm sorry. I'm going to take the remainder of my time and discuss the United Nations Declaration on the Rights of Peasants and Other Peoples Working in Rural Areas. This link to this will be provided to you with the video recording. It was adopted by a General Assembly vote. You can see on the screen who voted against it. The declaration defines that for purposes of the declaration, a peasant is any person who engages or who seeks to engage alone or in association with others, or as a community in small-scale agricultural production for subsistence and for the market, and who relies significantly, though not necessarily exclusively, on family or household labor and other non-monetized ways of organizing labor, and as a special dependency on and attachment to the land. The definition includes persons engaged in small-scale agriculture and handicrafts related to agriculture, indigenous peoples working on the land, and hired rural workers, including migrant workers on plantations and agro-industrial enterprises. I'm going to highlight some of the provisions. Obviously, I can't cover everything. The declaration obliges states to respect, protect, and fulfill the rights of peasants and other peoples working in rural areas. They are required to promptly take legislative, administrative, and other appropriate steps to achieve progressively the full realization of the rights set forth in the declaration. With respect to non-state actors, states shall take all necessary measures to ensure the non-state actors that they are in a position to regulate, such as private individuals and organizations and transnational corporations and other business enterprises, that these organizations respect and strengthen the rights of peasants and other people working in rural areas. The declaration contains numerous provisions on respecting the human rights of peasants and other people working in peasant areas, including the right to full enjoyment of all human rights and fundamental freedoms recognized in the Charter of the United Nations, the Universal Declaration of Human Rights, and other international human rights instruments. States shall take all appropriate measures to eliminate all forms of discrimination against peasant women and other women working. Judicial and political rights. Peasants and other people working in rural areas shall not be subject to arbitrary arrest, detention, torture, or other cruel or inhuman or degrading treatment or punishment, and shall not be held in slavery or servitude. Peasants and other people working in rural areas have the right to form and join organizations, trade unions, cooperatives, or any other organization or association of their own choosing for protection of their interests and bargain collectively. Food sovereignty rights. Peasants and other people living in rural areas have the right to land individually and or collectively. Peasants and other people working in rural areas have the right to the conservation and protection of the environment and the productive capacity of their lands, of the resources they use and manage. The right to the protection of traditional knowledge relevant to plant genetic resources for food and agriculture, including the right to save, use, exchange, and sell their farm-saved seed or propagating material. Peasants and other people working in rural areas have the right to enjoy their own culture and to pursue freely the cultural development without interference of or any form of discrimination. While the declaration has been put into effect, there is currently, I have not been able to find any cases where it's been cited in order to, as a defense against actions by states or non-state actors against peasants. That concludes my discussion.
Thank you so much, Jeff, for detailing the suppression of the landless workers in Brazil and the resistance and successes of the MST with help from the international solidarity movement and the efforts to hold Bolsonaro accountable in the International Criminal Court and also efforts in the General Assembly. Thank you very much. Our next faculty member is Galo Chiriboga Zambrano. Galo, the floor is yours.
Muchas gracias.
Thank you very
En
much.
primer lugar,
First of
quisiera
all,
felicitar las intervenciones
I
de mis
wish
dos
to
colegas que han
congratulate the
hecho
two
una
speakers who
magnífica
went before me,
descripción de
who
la
have
situación de derechos humanos,
laid out an
basados
excellent presentation of the
básicamente en
situation of
normas
human rights,
legales
primarily
que
based
violan
on
los derechos
legal
constitucionales
standards
de los
and
ciudadanos,
the
pero
constitutional
que sin
rights of
embargo, de
citizens.
ser tan evidente
But
la violación de tales derechos,
when
los
sometimes the
efectos
violation of these
prácticos
rights are
son
not as
muy
evident, the
lejanos.
practical
Y yo quisiera explicar
impacts
y conversar
are
con ustedes
impressive. I
en
would like
esta
to discuss with you
intervención que
during
agradezco a la Academia
my
Popular de
remarks. I'd
Derecho
like to
Internacional
thank
me haya
the
tomado en cuenta para participar
People's
en
Academy
este
of International
Bien,
Law for having
el
included
lawfare
me
contra
today.
defensores de derechos
Lawfare
humanos.
against human
Voy
rights
a plantear
defenders.
el caso
I'm
de
going
un
to lay
defensor
out
del
before
pueblo,
you the
el
case
más
of
importante
the
defensor del
Human
pueblo,
Rights Ombudsman, the
del
most
Ecuador,
important one
que sufrió
in
toda
Ecuador,
un
who
ataque en
underwent
su
a whole
dignidad y en su
series of
gestión
attacks
a
on
través del
his
lawfare.
dignity and his
Entonces,
work through
comencemos
lawfare.
por el marco
So let's
conceptual
begin
del
with the
análisis que vamos a
conceptual
hacer.
framework of the
La siguiente
analysis I'm
lámina,
going
por
to lay
favor.
out before you. Next slide, please.
La modernidad política
In
está
political
analizada por la
modernity,
sociología y sobre
as
todo por el
analyzed by
pensamiento de
sociology,
Michel
and
Foucault,
particularly the thinking of
quien ha
Michel
sostenido
Foucault, is
que
sustained
en su publicación Microfísica del
on
Poder
what he set forth in
considera que la
his
modernidad
paper, The
guarda una
Microphysics of
íntima
Power,
relación con la
is what
expansión
he
del
considers
capitalismo
that
industrial,
modernity is very
que
intimately
los grupos
related
de
to the
poder
expansion
de
of
la
industrial
burguesía
capital,
europea
and that
triunfante
the groups
precisó
in
definir
power of the
nuevas bases
victorious
de
European
legitimación al
bourgeoisie
ejercicio
needed
del
to
poder
define
político.
new
La
bases to
siguiente lámina, por
legitimize
favor.
the exercise of political power. Next slide, please.
Se diseña, por lo tanto, una
Therefore, they
institucionalidad del aparato
designed a
estatal
set of
para
institutions to
que
govern
configura el Estado
the
moderno,
state,
definiéndolo como un Estado de
which
derecho,
made up the
que
modern
tiene
state,
como
by
objetivo
defining it as the
situarlo,
rule of law.
sujetarlo,
Its
perdón, a
objective
la ley
is to
y así
subject
poder
it to the
poner
law
un
and in
límite
this
a
way
las
place limits
arbitrariedades.
on
Sin
arbitrariness.
embargo, esta
However,
representación teórica
this
de la institucionalidad
theoretical description
vendrá
of
acompañada
democratic
de mecanismos
institutions
disciplinarios
went
de
hand in hand
vigilancia
with
y control
disciplinary
que
mechanisms
marcan
of
la
surveillance and
existencia de la
control
vida humana.
that
Siguiente lámina, por
frame
favor.
the existence of human life. Next slide.
Sostiene el autor
The
que este
author
tipo de
says
poder
that this
que
type
inaugura la
of
modernidad
power, which was
se
ushered in
instrumenta
with
con una serie de
modernity,
mecanismos
is
de
made
sometimiento
possible with a
a
series
través de la
of
vigilancia y
mechanisms of
sistemas de control.
subjugation through surveillance
Creo
and
que
systems
son
of
muy claros
control.
estos sistemas de control
I
con
think the
las
systems
ponencias
of
de los dos
control have
colegas
been
que
made
ya
very
me han
clear in
precedido
the
en esta
presentations of the
presentación.
two colleagues who
Es
spoke
por lo
before
tanto
me.
un instrumento
Therefore,
fundamental en la constitución del
it
capitalismo
becomes a
industrial,
fundamental
por lo que
instrument
supone
of
unas
industrial
condiciones materiales
capitalism
que
in
evita la
which
presencia de
there
un Estado
are
soberano,
some material
poder
conditions
que
that
no
prevent
puede
the presence of a
traducirse
southern
en
state,
términos de
power
soberanía,
that cannot be
ya que
translated in
tal
terms of
concepto,
sovereignty,
aunque
because
no
that
desaparece,
concept, although it never
existe como
disappeared,
ideología del derecho
existed
que
as an
organiza los
ideology
códigos jurídicos que aparecen
of
en Europa
law,
del
which
siglo XIX.
was
Siguiente
organized
lámina,
under
por
the
favor.
legal codes that appeared in Europe in the 19th century. Next slide, please.
Foucault se pregunta
Foucault
¿Por qué ha
posed the
persistido
question,
la teoría de la
why
soberanía
has the theory
como
of
ideología y
sovereignty
como
persisted
ordenador de los
as an
grandes códigos
ideology
jurídicos?
and something
Aquí se
that gives
responde
order to
de
the
la
major
siguiente
legal
manera.
codes? He
La
answers
teoría
as
de la
follows.
soberanía
The
y la
theory of
organización
sovereignty
de un código jurídico
and
centrada en ella
the organization of a legal
permitieron
code focused
a
on
los
it
mecanismos de disciplina
made it
un
possible
sistema
for
de derecho que
mechanisms of
ocultaba
discipline to have a system of
procedimientos
law
disciplinarios
that
y lo que podría haber de
hid
técnica de
disciplinary
dominación,
procedures
siendo por lo
and
tanto
could
al
be
final del
used
día
as a
que la teoría de la
means of
soberanía
domination.
esté
Therefore, at the
presente
end of
en
the
el
day, the
aparato
theory of
jurídico
sovereignty is present
para
in the
hacer
legal
efectivo el poder,
apparatus in order to
desdibujando
have
el gran
effective
edificio
exercise of
jurídico
power.
político de la
And
soberanía
it
y convertirse
distorts the
en una
major
máscara de
legal
cubrimiento
edifice
de
and
las
the politics of
coacciones
sovereignty, and it
disciplinarias que
becomes
operan en el
a masquerade
sometimiento de la
to
sociedad.
conceal the coercion, disciplinary
Siguiente lámina,
coercion
por favor.
that our societies are subjected to. Next.
En este contexto,
It is in this
el poder
context
disciplin-
that
es en este
disciplinary
contexto
power
que el poder disciplinario opera el lawfare.
operates as
El
lawfare.
término, como ustedes conocen,
As you
debe entenderse
are
como
aware,
abuso
this
del
term
derecho
should be
internacional
understood as
para
abuse of
conseguir
international
objetivos
law
militares en
to
una
achieve
dirección, según la
military
conocida
objectives
definición del
initially,
general Charles
according to the
Dunlap.
well-known
Luego
definition
del
of General
atentado contra
Charles
las Torres
Dunlap
Gemelas en
after
2001
the attack on the
y de la
Twin Towers in
sanción del Patriot
2001
Act,
and
que
the Patriot
legitimó
Act,
la
which
aplicación de
legitimized
torturas a los
the
detenidos
use of
para obtener
torture on
información,
detainees for
quebrantando
obtaining
normas del
information,
derecho
which
internacional
was in
en el ámbito
violation
militar.
of international
Debemos
standards
entender
in the
entonces
military sphere.
como una guerra
Thus, we should
jurídica,
understand this
concepto
to
y
be
mecanismos
a
que se
legal
trasladarán
war,
también a la
a
política,
concept and
que no
mechanisms
solo
that also
contiene,
transfer to
no
politics,
solo en el continente
not
americano,
only in the
sino en
Americas,
otras
but also
regiones
in other
como
regions,
Europa
such
o en
as
algunos
in
casos.
Europe in some cases.
Siguiente lámina, por favor.
Next slide, please.
El lawfare, por lo tanto, es la judicialización
Therefore,
de la política
lawfare
y la
is the
politización de la
judicialization
justicia.
of
Y
politics
como lo
and the
sostiene Roberto
politicization
Saba,
of justice, as
el
stated by
llamado
Roberto
lawfare
Sava.
supone en su faz más profunda
The so-called
la negación de
lawfare
las instituciones de
supposes
la
at its
democracia
deepest level the
porque
denial
parte
of
de
the
una
institutions
concepción
of
diferente del
democracy
derecho
because it
y de
starts
la
from a
democracia.
different understanding
Siguiente
of
lámina, por
law
favor.
and democracy. Next slide.
El lawfare es un instrumento de combate
Lawfare
político
is an
internacional
instrument
también
of
nacional, como ya
international
veremos,
political
que se usa
battle
ese
that
poder,
is used
ese poder
by
sancionador
the person who
como
has the
una
power to
arma
sanction
por
as
algunos
a
actores
weapon
políticos que
uh,
buscan de forma ilegítima
used by some
objetivos
political
electorales
actors
que,
who
actuando de forma
illegitimately try to
legítima,
obtain
no podrían lograr.
electoral objectives,
Hace
which they
uso
could not
estratégico del
do
derecho
through
para
regular
fines de
channels.
deslegitimar,
Thus, they
perjudicar
strategically make
o
use of
aniquilar
law in
a
order
un
to
enemigo.
delegitimize,
Siguiente lámina.
harm, or annihilate an
Vamos
enemy. Next
entonces
slide.
bajo este marco
All right, so under this
conceptual
this conceptual framework,
identificar qué es
we
la
can
Defensoría del Pueblo en
identify
Ecuador.
what the
Quiero
ombudsperson is
comentarles que la Defensoría
in
del Pueblo
Ecuador.
en
And I'd like
Ecuador
to tell you that the
es un órgano
ombudsperson's
de
office
derecho
in
público, por lo
Ecuador
tanto,
is
previsto en la
an
Constitución
organ
de la
of
República,
political law. And
con
under
una
our
jurisdicción
Constitution,
nacional,
it has
con
national
personalidad jurídica
jurisdiction,
y
it has
autonomía
legal standing,
administrativa
and it
y
has
financiera.
administrative and
La
financial
Defensoría del
autonomy.
Pueblo fue creada
The office of
Constitución
the
de Montecristi
ombudsperson was
en el
created
gobierno
under the
del
Convention of
presidente Rafael
Montecristi under
Correa.
the government of
Su
President
titular,
Rafael
el
Cor-
defensor del pueblo,
Correa. The person who holds the
tiene
office
como
of
función proteger y
ombudsperson
tutelar los derechos
is
fundamentales de
to
los
has the
habitantes
role
del
of
Ecuador.
protecting and watching
Y
over the
cuando
fundamental
decimos
rights of the
habitantes del
inhabitants
Ecuador,
of Ecuador. When I say
incluye
inhabitants
a
of
los
Ecuador, this
nacionales
includes
y a
both
quienes no son
nationals
nacionales
and
y
those
están
who are not
cobijados
nationals
en el
but
marco de
live in
la
Ecuador.
República
They
del
are
Ecuador.
also covered by the law of the
El
Republic
defensor
of
del
Ecuador.
pueblo es
The
un funcionario
ombudsperson
que se elige
is
a través de un
someone
consejo de
who is
participación
elected
ciudadana,
through a
que
council
es
of
otra
citizens
institución de la democracia
Exploitation, which is another organ of Ecuadorian democracy that assesses the merits and knowledge of the applicants. And whoever gets the highest rating is appointed ombudsperson. And the person is sworn in before the National Assembly, which is our parliament, and also before the national courts. Next slide. One of the powers of the ombudsperson is the following: to issue mandatory measures that must be immediately complied with in order to protect rights and to request a trial and sentencing before judicial authorities, in this case, the prosecutor and the judges of the national court. And so these people operate under the national court. Therefore, the ombudsperson only works under the highest court in the country in judicial matters, the Supreme Court. In compliance with this position, Freddy Carrion, whose case I'm going to lay before you, created a truth commission to investigate the serious acts of violence that occurred during an indigenous uprising in 2019, which provoked brutal police repression that led Freddy Carrion to file criminal charges against the President of the Republic, his Minister of the Interior, and other authorities who were involved in that repression. Next slide, please. The reaction of the administration under President Lenin Moreno and his Minister of Government was to unleash tremendous persecution against Freddy Carrion. The National Prosecutor's Office accused him before the National Court because that is the jurisdiction under which the ombudsperson falls. They charged him with crimes that were never proven in a trial, and there was also no respect for the minimum guarantees contained in the rules that regulate due process. None of these principles were respected, and ultimately, Freddy Carrion was imprisoned. It was preventive detention, but it lasted 3 years. And that was the maximum sentence for the crime that he was alleged to have committed. Finally, the case of Freddy Carrion was a case of lawfare. And this is something that ombudsperson must bear in mind at times of legal crises, not only in their countries, but also within the structure of international law, because they may fall victim to lawfare itself and see no respect for their own guarantees in their countries, nor do they see timely resolution of this in international courts. I listened very carefully to the presentation by our colleague Jeffrey Frank and our colleague Mr. Zhang, in which they discussed the very serious violations of human rights that have occurred in their respective countries. And even in the specific case of what Jeffrey Frank was talking about in Brazil, there was charges were filed for crimes against humanity, and the International Criminal Court has not yet reached a decision on this. And we also heard under the both of these speakers efforts to go to United Nations agencies. And these international systems for the protection of human rights have not yet proven themselves to be effective. Therefore, lawfare is not only an attack on countries' democratic systems and constitutions in Latin America, which we're talking about here, but also at the international level and both European and general international law. I imagine that the crisis in international law is precisely due to the fact that both in our international law systems and also in our domestic legislation, this repressive power held by states is concealed, and they often exercise it, and in most cases, they do so with absolute impunity. I have also presented an executive summary of Freddy Carrion's case, and that is an annex to this presentation, and you may read that. And I've tried to provide this in a separate document in order to respect the time that has been very kindly ceded to me. Thank you very much. Okay.
Thank you so much, Galo, for explaining the use of lawfare to attack and suppress the ombudsperson of Ecuador, whose role it is to protect the human rights of the people of Ecuador. Thank you very much. Our next presenter is, thank you. Thank you so much for being with us. Our next presenter is Natalie Segovia. Natalie, the floor is yours.
Thank you, Marjorie, and good morning, good afternoon, everyone. And my apologies, bear with me. My throat is a little bit under the weather today. See, can you all see that? Great. So we've heard a lot about lawfare from several of my colleagues here that have presented today. And in particular, in the work that I do at the Water Protector Legal Collective, which is an organization that began at Standing Rock, what we see often is that we're fighting invisibility, and we're fighting the unseen struggles to protect protectors, right? Water protectors, land defenders, human rights defenders, to protect human rights and to protect the earth itself. In terms of protecting the earth and indigenous peoples and our role within that scope, worldwide, indigenous peoples make up only 5% of the world population, but protect 80% of the world's biodiversity. This is an often quoted statistic, but what is critical about understanding is that as we see projects for extractivism and in the context of just transition towards greener energy, the lands that are remaining are continuously whittled down. And so indigenous peoples are on the frontline struggles for existence and for the earth, not by choice, but out of necessity. And in these struggles, as indigenous peoples, were targeted by both state and non-state actors. So according to a UN report on criminalization, which will be shared also in the resources that are posted after this conference, indigenous defenders suffered nearly 20% of attacks between 2015 and 2022. So this was reported by the Indigenous Peoples' Rights International. Similarly, Frontline Defenders Global Analysis report in 2022 reported 401 human rights defenders killed in 26 countries. Every year, Frontline Defenders, which is an organization based out of Ireland, puts out a report documenting the targeting of activists and the targeting of defenders, human rights defenders, particularly in the areas of indigenous rights and environmental justice. These are the areas that are most at risk for represalias. And people do this work at great risk to their lives. Importantly, the United States is not covered in those statistics. So in 2023, we had the assassination of Manuel Tortuguita Terán, who was a non-binary indigenous two-spirit person who was killed for protesting Atlanta's Cop City in the Save We Ilani forest. So one of the things that we look at here is, how is the law being weaponized? We heard it from Jeff, and we've heard it from Galo, and looking at lawfare as an attack against democratic systems, against the rule of law. There are many definitions of lawfare, but in general, it is the use and weaponization of the law against systems of rule of law. So some examples of lawfare that we'll talk about here include criminalization of dissent, which is the main topic of today's conversation. Other ways of lawfare include strategic lawsuits against public participation, eco-terrorism language, and enhanced sentencing, which has been on the rise since the 1970s, arbitrary detention.
Can you slow down just a little bit for the interpreter, please?
Sure. Arbitrary detention and surveillance, which is part of the legacy of COINTELPRO. Private military and security companies, and we will discuss the use of these as well in the context of lawfare. So the criminalization of dissent. I think it's important to note that although we're seeing the rise of criminalization of dissent and state repression, the criminalization of Indigenous peoples within the context of dissent has deep historical roots and contemporary manifestations. So this dates back to origins of modern international law, as well as federal law in the United States, when colonial powers debated, implemented, and manipulated various legal norms to allow for just wars, forcible dispossession, enslavement, and even extermination, directed in particular at those who were deemed uncooperative or hostile. As we've seen in the past several years, especially since Standing Rock, there has been a rise in the criminalization of protest, specifically in the context of Indigenous-led climate justice movements. We saw a rise in criminalization at Standing Rock, at Line 3, and then again in Mauna Kea in Hawaii. At Standing Rock, there were over 800 arrests of water protectors, both Indigenous and non-Indigenous, the majority of which were dismissed. So the Water Protector Legal Collective, the organization which I direct, began at Standing Rock in response to the mass criminalization of Indigenous and non-Indigenous protectors who were being arrested. The question here is why we stand, right, as water protectors, as land defenders. Especially at Standing Rock, there was a need to protect both treaty rights and also to protect the water for future generations. So this is why people were discussed themselves as water protectors and not protesters. But in response, what we saw was excessive use of force by local, state, federal, and private military security companies. So as a result of Standing Rock in the years since, many of the things that we've seen include critical infrastructure laws that have been passed in Standing Rock, which make it illegal or otherwise enhanced sentences and criminalization for those that are protesting infrastructure, things that are deemed critical infrastructure, such as pipelines or other forms of fossil fuel infrastructure. In addition, we saw shared information between law enforcement and private military security companies. So Sheriff Kirchmeier from Morton County in North Dakota went on a speaking tour after Standing Rock, sharing information about how to deal with insurrection, right, which is how they viewed dissenters and how they viewed water protectors that were at Standing Rock. We've also seen SLAPP suits, strategic lawsuits against public participation, and enhanced sentencing. At Line 3, similarly, just a few years later, there were over 900 arrests of water protectors, Indigenous and non-Indigenous. One of the critical things in the context of extraction, and also why people stand against extraction and pro-water, is the link between pipeline extractivism and missing and murdered Indigenous women, girls, and Two-Spirit relatives. So in this article, the article discusses how in the process of approving the Line 3 pipeline, Enbridge, the Canadian company, was required to have a public safety fund in order to reimburse and to cover costs that would be associated with violence and potential human trafficking as a result of the pipeline. So in some ways, we see that the connection between extractivism and human trafficking, sex trafficking, missing and murdered Indigenous women, girls, and Two-Spirit relatives is something that's understood also by the corporations themselves. This is another reason why people stand against pipelines as a matter of existence and protecting future generations. Mauna Kea in 2014, Mauna Kea is on the Big Island, or Hawaii Island, one of the islands in Hawaii. This is a sacred site, a foundational and important mountain for the people of Hawaii. In 2014, they were attempting to build a 30-meter telescope, and they began a groundbreaking ceremony to begin building this 1.4 billion 18-story industrial telescope complex. Kanaka Maoli, or Native Hawaiians identifying as Ki'ai or guardians, interrupted the groundbreaking. Hawaii's Governor David Ige on July 14, 2015, signed an emergency rule and passed by the state's Board of Land and Natural Resources to criminalize Ki'ai. They described the June 24th blockade of TMT construction crews, suggesting rocks, boulders, and ahu, or altars, that were placed on the roadway, they said caused hazardous conditions. And so we saw in Mauna Kea the arrest of kupuna, or elders, over 30 of which were arrested and charged criminally. And Governor Ige said, "We cannot let some people put others at risk of harm or property damage." When the BLNR passed the rule, it labeled Ki'ai as an imminent peril to the public health or natural resources. So what we see is this constant language of risk and harm to property damage. And this is a recurring theme that we saw not only at Standing Rock, but since then again. And Mauna Kea is an ongoing struggle today. As far as strategic lawsuits against public participation, these are known as SLAPP suits. Importantly, Stephen Donziger was an example of a human rights attorney who was slapped with a lawsuit based on RICO racketeering charges. He was one of the attorneys that was involved in the Chevron versus Ecuador case in Ecuador, in the Ecuadorian Amazon, where Indigenous peoples were affected by the dumping of millions of gallons of oil and toxic waste. And as a result of the successful litigation, and I believe in an earlier course here at the People's Law Academy, Stephen spoke about this and about his case, so I won't belabor it, but it essentially resulted in a $9.5 billion judgment for the people of the Amazon in Ecuador, and they have yet to see a single dime. As a result of his advocacy, Stephen Donziger was imprisoned. He did 45 days in a federal penitentiary for a petty misdemeanor, for failing to hand over his personal communications and personal devices in the context of a RICO or racketeering suit. And similarly, he spent over 900 days under house arrest. So the attack on the rule of law and the use of lawfare, this is one of the critical precedents that is being set within the United States, where even a human rights attorney can be not only held under house arrest, but also disbarred. Also ongoing is the Energy Transfer Partners versus Greenpeace SLAPP suit. In this case, Energy Transfer Partners, which is the A corporation behind the Dakota Access Pipeline sued several organizations, namely Greenpeace, Earth First, Cody Hall, Crystal Tubles, several individuals, and other organizations that are not listed here. The case began in federal district court, and it was ultimately dismissed. It was dismissed for being a frivolous lawsuit. However, there were also state law claims within the federal case. And so when it was knocked out of federal court, it was refiled in the state of North Dakota. And currently this case is ongoing and set for trial this summer. So the basics of this case, it alleges defamation and conspiracy using RICO racketeering laws, which were used to prosecute gang members. And their argument is essentially that the Dakota Access Pipeline didn't threaten the water, that there was no unjustified violence against water protectors, and that there was no desecration of cultural or sacred sites. And so the defendants, like Greenpeace and other nonprofit organizations that were at Standing Rock, have defamed, according to them, and conspired to create property damage against the Dakota Access Pipeline. So this is an excerpt from the complaint, and it has some interesting language. It says the scheme was perpetrated by a network of putative not-for-profits and rogue eco-terrorists who have organized around common interests, goals, objectives, and stated purposes. Chief among them, the commitment to further an anti-development, no fossil fuel agenda through anarchist political philosophy and criminal sabotage. I think the importance of language is something that we can't undermine. This is something that they know well, and is something that they weaponize continuously against us. Between August 2016 and May 2017, the complaint continues, thousands of protesters descended upon North Dakota in an effort to prevent the construction of the final segment of DAPL. During that time period, hundreds of people were arrested when protests turned into violent clashes that placed the lives of construction workers, security personnel, and the local authorities in danger. Important to note here was that the protests at the Dakota Access Pipeline were peaceful. There were no weapons allowed at camp. And this is part of the narrative that they have been using as part of their SLAPP strategy to say that there was violence, and therefore that violence instigated by protesters guaranteed or warranted, the use of force and excessive use of force. And here they continue, they say, the myth is that these protests were organic, spontaneous, and peaceful. The reality is that opposition was a highly organized and orchestrated scheme perpetrated by out-of-state protesters who have political interests in the pipeline protest and hidden agendas vastly different and far removed from the Standing Rock Sioux tribe. So again, the complaint is out there. I welcome you all to read it and encourage you to read it. It's an important document that shows how the framing of a narrative has been really critical in strategic lawsuits against public participation, such as this one. So what we're seeing is a language as weapon, right? We are protectors, not protesters, but that is weaponized also against us. In the 1960s, 1970s, and through early 2000s, we have seen, we've had congressional hearings on the use of eco-terrorism or the terminology of eco-terrorism. So importantly, there was a Senate committee hearing on the crime of eco-terrorism in 1998. And the concept of eco-terrorism was coined by industry. So in this excerpt, here it says, during the hearing, Ron Arnold defined eco-terrorism for the committee as a, quote, crime committed to save nature, including every crime from trespass to murder. So Ron Arnold is known as given credit for coining the term eco-terrorism. And one of the things that they were fighting against was the Earth First activists who were part of monkey wrenching or placing spikes in trees, disabling machinery, and other acts against property. But that was seen as eco-terrorism. And so we saw the rise of eco-terrorist language and recognition of this by the Senate committees, subcommittees. Also, the FBI Counterterrorism Division. So in February 2002, James Farbo from the Domestic Terrorism FBI Counter Division also testified, and he said about the rise of extremist groups by disaffected environmentalists since 1977. He acknowledged that the most environmental and animal rights activists engaged in activities protected by constitutional guarantees of free speech and assembly, discourage acts that harm any animal, human, and non-human, but the volatile talk sometimes transgressed into unlawful action, resulting in property damage. The FBI further defined eco-terrorism as, quote, the use or threatened use of violence against innocent victims or property by an environmentally oriented subnational group for environmental political reasons. So again, here, importantly, eco-terrorism really linked to the use or threatened use of violence against property, being a critical piece of what we've seen in the critical infrastructure laws passed in Standing Rock, and then also in the enhanced sentencing that we've seen also since Standing Rock. As part and perhaps the most egregious application of eco-terrorism that we've seen in terms of enhanced sentencing is the case of Jessica Reznicek. So in June 2021, Jessica was sentenced to 8 years or 96 months in federal prison after she pleaded guilty to acts of property damage. So the Dakota Access Pipeline was not operational at the time. The acts of sabotage that she engaged in did not pose a threat to human life, but nonetheless, the federal district court applied a terrorism sentencing enhancement that increased her sentencing range from 37 to 46 months to 210 to 240 months. This terrorism sentencing enhancement was applied in response to a letter that was sent by 84 members of Congress, written to Attorney General Jeff Sessions at the time, requesting that Reznicek and other protesters who tamper with private property, again, a recurring theme, like pipelines, be prosecuted as domestic terrorists. The authors of this letter received a combined $36 million in campaign contributions from the oil and gas industry. We've also seen arbitrary detention as a form of criminalization of dissent. Critical in this sense is the case of Leonard Peltier, who is an Indigenous elder, 79 years old, going on 80, who has been in prison for nearly 50 years. He was sentenced to prison for 2 consecutive life terms for the killing of 2 FBI agents, which he has maintained his innocence. And the government agents have actually disavowed his conviction. One of the original leaders of the American Indian movement, which was founded in 1968 as part of the civil rights movement, AIM occupied the Pine Ridge Reservation in South Dakota in 1973. At the time, there was confrontation with the FBI, who were also on the Pine Ridge Reservation, and over 60 Indigenous peoples were murdered or went missing and presumed dead at the hands of the FBI and other law enforcement authorities. Mr. Peltier's trial and subsequent parole proceedings have been marred by historical bias, anti-Native American bias. On July 9th, 2021, former U.S. Attorney James Reynolds, who helped put Mr. Peltier in prison, wrote to President Biden, quote, "I have realized that the prosecution and continued incarceration of Mr. Peltier was and is unjust. We are not able to prove that Mr. Peltier personally committed any offense on the Pine Ridge Reservation." Similarly, on June 7th, 2022, the United Nations Working Group on Arbitrary Detention issued an opinion demanding that Mr. Peltier be released, demanding compensation or other reparations, and an investigation into violation of Mr. Peltier's rights. Again, this working group opinion on arbitrary detention recognized that His sentence as a political prisoner and being held as a political prisoner is due to anti-Native American violence and discrimination, but also due to his activism as a member of the American Indian movement. So Mr. Peltier has a parole hearing coming up next week on June 10th. We invite you all to send good intentions and good prayers his way as his legal teams move forward in that regard. But arbitrary detention, in the case of Mr. Peltier, is probably the most egregious as the longest serving US political prisoner. But we also have seen it in other cases and instances as part of the political prisoners from the Dakota Access Pipeline. And then again, Jessica Resnicek and Stephen Donziger. The history of surveillance, we've seen it in the past and we are seeing it today. So in the 1960s, COINTELPRO was used against liberation movements. The Black Panthers, the Brown Berets, the American Indian movement, who were seen as dissidents, were heavily surveilled by the FBI. And it was meant to do counterintelligence. It was a counterintelligence project. Although it was dismantled, present-day counterinsurgency tactics continue, including heightened surveillance and violations of the rights of privacy and association. In 1976, the Senate Subcommittee or Church Committee found that COINTELPRO engaged in massive human rights violations, targeting US citizens based on race, political ideas, and political affiliations. This is something to keep an eye out, particularly as the protests in Palestine continue, and the protests in the US continue with the targeting of protests here, and also the surveillance and doxing that we are seeing across the US. Also at Standing Rock and other front lines, private military and security companies, PMSCs as they're known, are private contractors engaging in conduct amounting to cruel, inhuman, or degrading treatment. And these as non-state actors, there's no accountability mechanism or oversight for the human rights violations and abuses that they commit. This has been a problem widely recognized by the United Nations. As an example, at Standing Rock from September 2016 to February 2017, Energy Transfer Partners hired at least 76 city, county, state law enforcement, mobilized the National Guard, and used private security firms, including Tiger Swan. Tiger Swan is a US Department of Defense contractor with offices in Afghanistan, India, Iraq, Japan, Jordan, Latin America, Saudi Arabia, and the US. And their operatives are trained in counterterrorism operations. PMSCs are known as a euphemism for mercenaries. They constantly share information amongst each other. And there was great reporting done by Aline Brown of The Intercept and at the Grist about the former military operatives and counterinsurgency and counterterrorism operatives that make up the private military and security companies that see water protectors as jihadists, as terrorists. And I'm using that intentionally. It was a quote from some of their own documents that described water protectors at Standing Rock as terrorists, as eco-terrorists. So again, the weaponization of language is part of the lawfare that private military and security companies use against Indigenous peoples and their allies. So to wrap, there's so much that we could talk about in terms of the criminalization of defenders. But we are also looking at what are the ways that we can protect the sacred, right? What are the ways that we can protect the earth, that we can protect protectors that are putting themselves on front lines to do this work? And what are the resources that international human rights might be able to afford, particularly when domestic frameworks, or in this case, the US framework, might fall short of some of the protections that are very much needed. But without completely dismantling or completely ignoring the national frameworks that we find ourselves in it's important to find too the hooks for international law that we can use in the advocacy that we put forward. So the United States Constitution Supremacy Clause is an important part of this within international human rights law as a way of guaranteeing the rights of Indigenous peoples is the UN Declaration on the Rights of Indigenous Peoples and the Free, Prior, and Informed Consent Standard. The Supremacy Clause of the Constitution, for those of us that work in human rights, this is an area that we constantly quote and cite in our legal briefs within the United States and use it to our benefit. The Constitution, Article 6, Clause 2 says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land." It's important to note here that we are talking about international treaties, treaties also with Indigenous or Indian nations, original nations. And this is one avenue of being able to use international human rights frameworks within US litigation and advocacy. So very, very briefly, the UN Declaration on the Rights of Indigenous Peoples as a tool for advocacy has been, was over 30 years in the making. It was finally adopted by the General Assembly on September 13th of 2007. And over 143 UN member states voted to adopt the declaration, 4 voted against. You can imagine some of the countries that voted against included the United States and Canada. All 4 countries that voted no have since changed their positions and now support the declaration, but many of these have stopped short of actually ratifying the declaration itself. Some important UN DRIP articles include the collective right to human rights recognized under international law for Indigenous peoples, the right to non-discrimination. Articles 3 to 5 address self-determination, which talk about the importance of economic, social, and cultural development and the right to self-governance. And Articles 11 to 13 address cultural and language preservation, as well as the preservation of spiritual traditions. So why I'm citing these is because oftentimes Indigenous peoples that are standing at front lines are standing because of discrimination, because of a lack of self-determination, because there are impacts to the economy, to their economic, social, and cultural development, as well as spiritual traditions, protecting the sacred. Importantly, Article 19 says that states shall consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions in order to obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. Within the United States, we have a requirement of tribal consultation. The tribal consultation often becomes a check mark in a perfunctory process that is not participatory and has been highly criticized for many years. And so we argue for this standard of free, prior, and informed consent to be adopted, particularly in cases of extractivism. So what does this mean? Free, prior, and informed consent means that consent is free, without coercion, is given voluntarily, and self-directed by the community. It is prior, it is sought sufficiently in advance of any authorization or commencement of activities. This is important because often tribes or Indigenous nations receive information at the last minute or when a project has already been permitted or is nearly underway. Informed, the engagement and type of information should be provided prior to seeking consent and also part of an ongoing consent process. And finally, consent should be part of a collective decision made by the rights holders and reach through a customary decision-making process within communities themselves. So what we see here is that free, prior, and informed consent is a standard that goes beyond consultation And it's a needed prerequisite for any activity that affects Indigenous ancestral lands, territories, or natural resources. This would be one way to curb the rise of criminalization of dissent, particularly against Indigenous peoples. FPIC, or Free Prior Informed Consent, recognizes the inherent and prior rights of Indigenous peoples to their lands and resources, and respects legitimate authority to require that third parties enter into an equal and respectful relationship with them based on this standard. So what we see with recent and ongoing fossil fuel and other actual or proposed extractive projects is that these threaten existence, the right to subsistence, the right to self-determination, religious and cultural rights, and also access to water for future generations of Indigenous peoples. Important within this too is the concept of green colonialism, often used interchangeably with greenwashing. This term refers to initiatives or projects by government or corporations aimed at a transition to greener energy, conservation efforts, or sustainable development. But they rely on extraction of natural resources like lithium, cobalt, nickel, copper, or otherwise impact water, ecosystems, and result in the destruction and desecration of ancestral lands, sacred sites, displacement of Indigenous peoples, and a violation of the standard of free, prior, and informed consent. The term highlights the parallels between historical colonialism and contemporary environmental interventions, where the dominant group seeks to control or exploit resources and land under the guise of environmental protection or sustainability. In the search for green energy, we can't settle for false solutions that put Indigenous peoples, water protectors, and land defenders at risk of continued criminalization and continued risks to their lives. So what we see is that history continues. There are front lines everywhere due to extractivism and in the context of a green transition. So some examples include the Coda-Access Pipeline, Line 3 pipeline, the Willow Project in the Arctic, Mountain Valley Pipeline in Appalachia, fracking at Chaco Canyon in the Southwest, a proposed copper mining operation at Oak Flat, which is in violation of the White Mountain Apache treaty rights, proposed lithium mining at Thacker Pass, also affecting Paiute and Shoshone peoples of Duck Valley, proposed in Nevada, proposed 30-meter telescope on Mauna Kea, which has been opposed for over 50 years by the community, proposed gold mining in Haisapa, or the Black Hills, which happened already once, and the gold mining created issues for water, so people are again opposing it because history tends to repeat itself, and we hope that we can learn from it. Militarization is another one that I haven't talked about extensively here, but leads to the criminalization of dissent and impacting Indigenous peoples and lands and waters. So specifically at Pohakuloa training area on Hawaii Island and the Atmos telescope on Haleakala, which is being proposed to be built by the Air Force in support of national security measures. And uranium mining at Pinyon Plain Mine on Navajo lands and Dinata, used extensively for the military industrial complex. There is, again, more than we could possibly cover in this short time, but I invite you to read the shadow report that the Water Protector Legal Collective submitted to the on the ICCPR in 2023. These links will be shared, as well as a report that was issued by the Permanent Forum on Criminalization of Indigenous Peoples' Human Rights just this February 2024. And I think in closing, I'll lead with the ability that we have. I know that people come together here and for the People's Law Academy to not just hear about the difficulties of the law, but also look at the possibilities of the law. And what I've seen over and over again is that Indigenous peoples that are coming together, allies coming together, and also legal allies, right, as lawyers and attorneys working in front lines, as community organizers working on front lines, we have an ability to come together and to make collective change by making sure that our voices are unified with purpose and intent, and also knowledge, right? Knowledge is power. So having these resources, knowing what it is that we're up against, and going in eyes wide open with the knowledge of the history that we've seen before, and a hope for what we are also fighting for, not just fighting against. Thank you.
Thank you so much, Natalie. And now everyone can see how delighted we are to have Natalie as a member of the scientific committee of the People's Academy of International Law. Thanks, Natalie, for your excellent presentation about the criminalization of Indigenous peoples, the critical work of frontline defenders and protectors, and the resultant repression and weaponization of lawfare against them, including allegations of so-called eco-terrorism against property, and the use of international human rights law and strategies to protect Indigenous rights. So thank you so much for that. The next portion of our program today is going to be a discussion between our faculty members, Zhang, Jeff, Gallo, and Natalie. And I wanted to just start off, and if you have questions, please put them in the Q&A box. I just wanted to thank Natalie for mentioning the Supremacy Clause of the Constitution, because so many times we hear not just lawyers, but judges, including so-called justices, I never refer to them as justices, members of the Supreme Court, talking about international law as if it's something out there in the stratosphere that doesn't bind us. And under the Supremacy Clause of the Constitution, treaties are the supreme law of the land when we've ratified them. But even when we have not ratified treaties, we have obligations under customary international law. And these are legal tools we need to use to fight back against the continuing oppression and repression of people. So now I want to open up the discussion now to the faculty members to raise issues or react to each other's presentations, or just make any kinds of comments that you like. So go right ahead.
I was going to ask Natalie about the state laws that were enacted against the water protectors, and how they've been combated, if they've been able to be.
Yeah, thanks, Jeff. I noted too, you brought up eco-terrorism and the use of eco-terrorism by Bolsonaro in Brazil, and the language, right, the weaponization of language. I think in the context of the United States, with critical infrastructure laws being passed after Standing Rock, it was a political lobbying effort that we saw by members of the oil and fossil fuel industry to create these laws, right, and to pass these laws in, I want to say, over 40 states. I don't have the exact number on just the top of my head here, but it was in many, many states across the U.S. And the result of that, has led to states having increased penalties for this kind of protest around any kind of pipeline infrastructure. So that means even if something is in construction, under construction, not operational, this could lead to criminal charges, and oftentimes elevated criminal charges, including felonies, which was not the case prior, right? It used to be a misdemeanor, or you could see things like in the case of Jessica Reznicek, issues that were brought up as criminal sabotage, specifically targeting property, but not with the focus and with the slant of impacting national security, which is what these critical infrastructure laws really go to the heart of. And so framing fossil fuels as a protection or protecting fossil fuel infrastructure as protecting national security is part of the lawfare that we're seeing, is part of what we're up against as in the process of protecting protectors and protecting the earth. I hope that answers your question.
We certainly see a common theme running throughout all of these different cases of repression, that it is the elite interest, the money interest, and really capitalism that is driving this repression. Other comments from faculty members?
I know several of us spoke about lawfare, and for Dr. Gallo, one of the questions that I had is in terms of your definition of lawfare, you were talking about a crisis of the rule of law. And this is also how I would see lawfare, right? The rights that we're seeing is these are under attack, and that democracy and democratic systems are under attack. If you could share a little bit of the experience that you've seen in Ecuador from the time that Correa was in office to the present, and seeing how some of the developments, particularly in the global South, across Latin America, across Africa, across other countries have been impacted by this crisis of the rule of law. And thank you for your presentation.
Yes, thank you very much for the question. The fact is that in Ecuador, we underwent a radical change, starting with the Moreno administration, which is a government that is fundamentally aligned with the interests of the Ecuadorian oligarchs and multinationals. First of all, I wish to remind you that under the Rafael Correa administration, through an assembly, we passed a new constitution, the Montecristi Constitution, which in fact defines nature as a subject holding rights, which is a very important development. Secondly, the Montecristi Constitution broke with the traditional structure of a state under the three branches, the judiciary, the executive, and the legislative branch. But rather, there were 5 branches of government, including those 3. So there was also the Council of Citizens Participation, which is the agency that receives that's where all the competitions take place to elect the other government authorities. And so this removes them from the parliament or from more political system. If all of this system destroyed in practice, Ecuador is now undergoing a situation of very serious violations of human rights. And you referred to the case of Chevron, which is one in which Rafael Correa waged a very important campaign, and which ended, as you mentioned. So it occurs to me that the constitutional system in our countries has been seriously wounded, including with the passage of laws that you've mentioned to repress the right to protest over environmental issues and the rights of native peoples, etc. I see that the response of the international system and the treaties that we, several of us referred to, are insufficient. In other words, it seems that you don't get an answer until several years later, and damages have become atrocious. by that time. Therefore, it seems to me that the work that is being done by human rights organizations also needs to be pushed. We need to work with the United Nations agencies to see how its statements could be more timely, first of all, and secondly, to make sure that their statements enjoy the respect of the member states of the United Nations, so that countries, as Marjorie said, just like the Constitution of Ecuador, has our legislation that are subject to international treaties, which are legally binding in Ecuador. So it's a legal matter to think that an international decision, because it's in the international realm, cannot be applied domestically in the country. So it seems to me that we could make improvements in terms of effectiveness. So we could work on the human rights defense agencies, human rights defenders, and make a major effort, and they sometimes sacrifice their lives, often with very ineffective outcomes. The structure of the United Nations systems, I believe, is inoperative, and this it might help us overcome this national and international crisis in terms of protection of human rights. So that's my response, Natalie.
That's yes.
Thank you.
Other comments from faculty members? No? Okay. Well,
Well, I
yes.
was going to ask Jean about the efforts to repeal the national security law he talked about. And have they gone anywhere, or have there been any efforts?
Do you mean the abandoning efforts in South Korea? Am I right? The abandoning efforts in South Korea.
Well, the efforts to get the law repealed, taken off the books, I should say.
그 국가보안법 관련해서 유엔에서 끊임없이 국가보안법 폐지 권고를 한국 정부 해오고 있지만 국내에서는 한국 국회 국가보안법 폐지 입법안이 지금까지 단 한 번도 통과가 되지 않을 정도로 보수 세력들이 국가보안법을 가지고 한국 이 분단된 상태에서의 그 국민들이 북과 관련된 된 부분에서는
Don, could you translate?
Yes, regarding on the abandoning efforts in the UN, actually we have submitted the many reports to abolish the national security law, but it has failed again and again, and it's still in the National Assembly in South Korea, still they do not allow that taken the bill to abolish. And actually, the conservative forces try to maintain this national security law under the division of Korea. So any remarks or the thoughts related with the DPRK, and it is threatened under the violation of the national security law. It's still active in South Korea. Of course, there were many efforts to abolish, but it was not succeeded.
We have a question about the rise of McCarthyism against pro-Palestinian advocates. And I would like to just start by updating people that what has happened in the last couple of days is that a very reputable scholar who is in a PhD program at Harvard wrote a, I believe, 100-page law review article that took 5 or 6 months to write. Harvard Law Review turned it down. Columbia Law Review published it, and as soon as it was up on the Columbia Law Review website, the powers that be took down the entire website with some kind of cock and bull story about how they had to revise the website. Just the latest example of McCarthyism and attacks on pro-Palestinian voices. Also, we see the use of the weaponization of anti-Semitism to attack people who are advocating against the genocide that Israel is perpetrating in Gaza, now in its 8th month, and people's advocates around the world in solidarity with the Palestinian struggle. And we've seen students, the campus is erupting all over the world. I think almost 200 now, maybe more, having encampments, having protests, having demonstrations, and the repression that comes down against them. But nevertheless, maintaining that opposition, that struggle, and we see that all over the country. So much so that I think Biden has noticed, although not very much, trying to get a peace agreement, but not enough to undermine his aiding and abetting of the genocide by sending weapons to Israel to use against the Palestinians. Those are just a few comments. If anybody would like to say more about that issue or other issues, please feel free. And we also have a concomitant question about how best to defend the rule of law and attack on international law, most clearly in the case of Israel now and its genocide against the Palestinians.
Marjorie, I just shared an article in the chat, and this was a letter that was published on May 14th, 2024, to the Department of Treasury, requesting the Committee on Oversight and Accountability and the Committee on Education, or rather from the Committee on Oversight and Accountability and Committee on Education, having grave concerns about pro-Palestinian organizations. And it lists, several organizations, 20 in this letter. But the rise of McCarthyism was something that, at least when I was in high school and middle school learning about these things, was definitely something that we talked about as something we never wanted to see repeated again in the United States or in the history of countries that respect the rule of law. And what we're seeing again is is on par with the kind of Red Scare, just on a different level. But the kind of witch hunt that happened and the witch hunts that happened during the McCarthy era, something that we're seeing again here. We're seeing it, and we've seen it in the defense of water protectors and defenders over the past several years. And I see this as a different iteration of the same problem. But wanted to share that letter with you all in the chat in case folks haven't seen that.
Yes, thank you for that, Natalie. And also we have the orchestration of US foreign policy by the Israeli government, not just in our executive branch in the United States, but also in our legislative branch, where AIPAC is one of the biggest donors, the pro-Zionist, anti-Palestinian AIPAC. So much so that the House of Representatives, virtually all Republicans and a very sizable number of Democrats, voted to impose sanctions against the International Criminal Court if they issue arrest warrants against Netanyahu and Gallant. And of course, that's a direct attack on the rule of law, on international law and international accountability, and the International Criminal Court. Are there
I don't
other?
mean to dominate,
ahead.
but just on the question of rule of law, you know, one of the ongoing questions and one of the things that we've heard as criticisms often about international law is what's the use of international law if it's not enforceable, right? And this is the critique that I think most international human rights lawyers hate to hear often. But there's a kernel of truth in that. The frustration that people see with the application of international law is the constant whittling down and diminishing of the rule of law as part of, and also customary international law, right? And international law in ensconced in treaties and international instruments. One of the things that I see as the best way to defend the rule of law and is honestly education. I think part of the difficulty that we have is a constant erosion of knowledge about the rule of law, about international law, about the contents of treaties, and we have to fight back against misinformation and malinformation, information that is specifically used to harm and create harm, by also being able to share information about international law and how this can be used. I think it's difficult because we're not taught this, right, in the majority of law schools, if you're a lawyer. And in community organizing, I think organizers and defenders look to many resources that could be used, right, and look to cases like international law to further the rule of law that is so often absent in the countries and the national frameworks that we are a part of. So I think in some ways it's also combating the ignorance and the rooting out that ignorance that we unfortunately collectively create.
Yes, I'm glad you brought that up, Natalie, because that's a theme that, of course, has run throughout our programs at the People's Academy of International Law, and that is the enforcement. We have all these laws, international laws, treaties, declarations, covenants, conventions, part of domestic law in most states. But what about the enforcement? And one of the things that is important to keep in mind is that there is a concept in international law known as the mobilization of shame. The mobilization of shame, where countries like the United States, countries like Israel, countries like Brazil are shamed in the eyes of the international community. And when we have lawsuits brought in the International Court of Justice, when the International Court of Justice says that there's a plausible case that Israel's committing genocide against the Palestinians in Gaza, when the International Criminal Court, which has resisted any kind of accountability for war crimes, crimes against humanity by Israel, after 7 years of examination, investigation, finally, the mass mobilization of people all over the world outraged at Israel's genocide has gotten the attention of the International Criminal Court, and particularly Israel's invasion of Rafah. And so much so that NGOs and people all around the world are calling for sanctions against Israel, arms embargoes. And so this is an example of the interplay between international institutions and people's movements to make real change. I'm just looking at the chat here. Okay. Do any of the other faculty members want to make any comments, or do the attendees have other questions that you want to put in the Q&A box or the chat box? And if not, I want to thank all of our faculty members, Jeff, Gallo, Natalie, and especially Zhang, who has stayed up from 1 a.m. to 4 a.m. in South Korea to give a wonderful presentation and participate in this program. Our next program of the People's Academy of International Law will be Seminar C, which will be held on Thursday, June 27th. It will be a 2-hour program from 9 to 11 a.m. Pacific time, 12 to 2 o'clock p.m. Eastern time. And the topic for Seminar C will be abolition of nuclear weapons and nuclear power plants. The faculty for Seminar C includes John Burroughs, Terry Lodge, and June Sasimoto. And Seminar C will be our last program before the People's Academy of International Law takes a summer break. And after the June 27th program, we will come back in the middle of September. So if there are no other comments, I want to thank you all for coming and being part of this important program. And we hope to see you all on June the 27th. So thank you so much.